Last week, President Biden issued an executive order announcing a new parole-in-place program meant to help the spouses and children of U.S. citizens be able to get a green card inside the U.S. without having to leave. Normally, this process not just requires persons to have to file for a waiver and to go through the consular process, but the very fact that people would have to leave the U.S. in order to receive their immigrant visa to get a green card in the U.S. puts families at huge risk of years of separation in case of a denial overseas. However, this new program will give spouses of U.S. citizens and children underneath 21 protection against deportation and give the ability to apply for a green card and a work permit inside the U.S. without having to leave, so that they can stay together with their family while they wait for their adjustment of status process to finish. The Department of Homeland Security estimates that an approximate 500,000 spouses of U.S. citizens and their children underneath 21 years old may be eligible for this program. So in today's video, I am going to do a deep dive into who may be eligible, how you can apply, and what documents you may need for this process. DHS has mentioned that persons who inappropriately apply for this program may end up in removable proceedings to get deported, so follow closely and pay attention so that you don't make a mistake. It is important to note that while the executive order has been announced, the official policies regarding the forms, paperwork, and documentation that is required to apply for this program are not necessarily official yet. However, we have many clues on what may be necessary based upon the other parole-in-place programs that are already authorized by the Department of Homeland Security. So let's take a look to see what you may need. First of all, what is parole in place? This is essentially the government's way of giving you permission to be here inside the United States, and in a way, it essentially erases that one unlawful and illegal entry that you may have that prevents you from doing the process for adjustment of status inside the United States. Therefore, even if you have entered the United States illegally and without permission, once you have achieved parole in place, you are essentially deemed to have an inspection and admission into the United States, and with this inspection and admission, aka parole in place, you can then file for adjustment of status, which means that you would not need to leave the US in order to get your papers. While the Department of Homeland Security has not exactly made the requirements for parole in place documentation available, here is what we assume will be required. Number one, you will need to show proof of qualified marriage to a United States citizen. That means that you must show a marriage certificate to your US citizen spouse, and your marriage certificate must show a marriage date from June 17th, 2024 or before in order to qualify. And if you have ever been married in the past, or if your spouse has ever been married in the past, you will also need to show proof of termination of prior marriages. Next, you'll need to show proof of your identity, proof of good moral character, evidence of continuous residence, and for any children that you have, proof of their birth certificates. Because the list of exact documentation is not yet published, this is just a general guideline, and further instruction must be found on the DHS website once it is released. Based upon other parole-in-place programs that are currently authorized by DHS, most likely the parole-in-place request must first be approved before you can file for your adjustment of status application, and along with this adjustment of status application, you will then be allowed to file for a travel document request as well as a work authorization. DHS has announced that the criteria and documentation requirements as well as the exact process for applying for this parole-in-place program will be available by the end of summer 2024. Now, DHS will be considering eligibility for parole in place on a case-by-case basis. However, here are the criteria requirements that we do know about so far. Number one, in order to be eligible for parole in place, you must be present in the United States without inspection, admission, or parole. You must have been present in the United States for at least 10 years continuously before June 17th, 2024. You must have a legally valid marriage as of June 17th, 2024, or from before. You may not have any disqualifying criminal history, and you may not otherwise constitute a threat to national security or to public safety. And you must be otherwise eligible to adjust status. for an undocumented child underneath 21 to qualify, they must also be physically inside the United States without parole, admission, or inspection, and have a qualifying relationship to a U.S. citizen parent as of June 17, 2004. This means that their parent must have married a U.S. citizen before they turn age 18. So here are some of the people for whom this parole in place program would not apply. Undocumented persons who have been inside the United States for less than 10 years. Anyone who got married to a United States citizen after June 17, 2024. Anyone who has the permanent bar. Anyone who does not have continuous residence of 10 years before June 17. Anyone who has disqualifying criminal convictions, including convictions that would render them ineligible to adjust status. And persons who entered with a visa. Now, here are some important things to keep in mind about this program. Once this program is announced, it will probably be important to make your application as soon as you can, especially before the election. If Trump gets elected or the program gets stuck in court, then it will create a barrier for anyone who has not submitted their application prior to the program getting stuck. Most likely, if your application gets submitted even before the program may potentially get held up by litigation, it will still get processed or it will still be considered for processing. If you have any sort of criminal history, it is imperative that you get your case evaluated by a qualified immigration attorney because serious criminal convictions can put you at risk of deportation. So it's critical that you ensure that you are actually qualified before you submit your application. It's a good idea to meet with at least one lawyer or maybe even two to get your criminal records analyzed. For this, you will need to do the groundwork and obtain your criminal records from the courthouses where you have convictions or arrest history. I caution you, do not rely on word of mouth advice from persons who are not qualified to deal in this area. You may also want to now start collecting evidence of your physical presence inside the United States for the past 10 years prior to June 17, 2024. Whenever I have submitted any sort of paperwork regarding physical presence for a client, I always ensure to try to include information on a month-by-month and year-by-year basis for all of the years in question. And if you think that this may amount to a lot of paperwork, you are probably right. It is better to err on the side of caution to show that you have as much evidence as needed to establish 10 years of continuous residence inside the United States. Try to do the groundwork for gathering this documentation right now, and you can get creative by getting rent receipts, tax records, pay stubs, school records, medical bills, doctor's bills, and even proof of the birth of your children inside the United States. A lot of these documents will help you go a very long way in establishing physical presence here. Next, I have been asked whether a common law marriage would also qualify for this program, and the answer is yes, as long as your marriage is considered to be valid in the state in which you live. Even if it is a common law marriage, you should qualify for parole in place because common law marriages are accepted by USCIS as legally valid marriages. Be sure to check the rules in your state to find out what is required in order for a marriage to be considered a valid marriage when it is common law. And lastly, another question that I have been getting a lot is whether persons with a permanent bar will qualify for this program. Now, the new parole in place program does say that a person must otherwise qualify for adjustment of status in order to be eligible for parole in place. A person who is filing for adjustment of status may generally not be able to waive the permanent bar unless they are seeking waivers through VAWA or a T visa or a U visa application. And generally speaking, parole in place does not give you any of this. So my general feeling is that parole in place will still not help persons who have the permanent bar inside the United States. To find out whether your entries and exits make you ineligible due to the permanent bar, you will need to supply this information to a qualified immigration attorney who has experience with this subject matter. My best advice to you right now is to start gathering your documentations and stay up to date on the news. Because we expect this program to take 2 to 3 months to be finalized, you will be hearing back before the end of the summer, hopefully with further instructions and more concrete details about how to apply for parole in place. And if you still are not eligible for parole in place, do not lose hope. There may still be other programs such as the T visa or the U visa or even VAWA that may help you get your legal status inside the US without having to leave. I'll be reporting on all the details on the new program as soon as they are available. Subscribe to my channel so that you can stay up to date for future updates. And if you have any questions about this program, make sure you leave me a comment and I will do my best to respond as soon as I can. My name is Moumita Rahman. I have been practicing immigration law for 14 years. Although I am based in New York, I serve clients all over the United States, and we focus on humanitarian applications. If you would like an appointment with our office, call us at 212-248-7907 today.